Dr. Khatade. It's indeed an honor and a pleasure for me to be invited to deliver this lecture after such illustrious speakers as Suhash Palshikar ji and Pratap Bhanu Mehta ji. I've been asked to talk about the state of the judiciary and the reforms required in the judiciary. In order to understand that, we first need to understand what is the role of the judiciary that is envisaged by our constitution. So broadly, the judiciary is expected to play two kinds of roles. One is to resolve disputes and decide disputes between individuals and between individuals and the state, and sometimes between state and state or state and the union. But the other equally important role of the higher judiciary, the high courts and the Supreme Court, is to protect the constitution from encroachment by the executive or by the legislature, to protect fundamental rights of the people from transgression mainly by the executive and the legislature, and to protect democracy and democratic institutions in the country. Now, if we examine how the judiciary has fared, the judiciary in India has fared on both these aspects, that is, how successful has it been in delivering justice to the people, and secondly, how successful has it been in protecting fundamental rights, democracy, democratic institutions, and the constitution. So we will come to the following conclusion. On the question of how successful the judiciary has been in delivering justice, and if we ask what percentage of people in this country are able to get justice, effective justice through this judicial system, the honest answer would be very, very few, perhaps not even 1 or 2%. The reason for that is that in the first instance, the majority of people in this country, probably more than 80% people, are not in a position to afford the fee of lawyers or afford to engage lawyers to take their disputes or to defend themselves in the courts. So therefore, these people are left completely helpless when they have to face the judicial system. They cannot approach the judiciary, and if they are charged with any offense, they cannot defend themselves. They just stand helplessly in front of the police officer or the court and ask for mercy. And that is why the majority of the prisoners in jails in India are under trials. They are not convicts because these people do not even have any means for arranging their bail. The second problem is delays. Even if for those, let's say 20% people in this country who have the wherewithal to engage lawyers and approach the courts or to defend themselves, cases keep getting delayed for decades altogether and get decided after a decade or 2 or 3, by which time it has become meaningless. And thereafter, even when the case comes to be decided, suppose some people are lucky enough to have their cases decided quickly, very often the judgment is wrong. It is wrong because the judge is incompetent or because the judge is corrupt. So there is a huge problem of incompetence as well as corruption in the judiciary, both in the lower judiciary as well as in the higher judiciary. So ultimately, there are very, very few, minuscule percentage of our population who can get effective justice through this judicial system. I'll come to the solutions. Secondly, if we ask this question, to what extent is the judiciary of this country, has it been successful in protecting fundamental rights, democracy, and our constitution? Well, at least as of today, the answer would be what Justice Shah said in his lecture, in his Justice Suresh Memorial lecture day before yesterday. He said that at least during the last 6 years, during the Modi years, the Supreme Court in particular has collapsed, and it has not been able to protect fundamental rights or this or the constitution or democracy against the onslaught on all these things, on fundamental rights, on democracy, on our constitution, by a very strong majoritarian fascist government. So, and that is why we have a situation in this country today where democracy has more or less collapsed. In fact, today something very extraordinary happened. Of course, for the last 6 months, Parliament was not in session. But just a few days ago, Parliament was again opened from Monday, and this farm bill, which were 3 ordinances which the government had issued, put together, they were to be passed, and when it went to the Raj Sabha, where the government did not have a majority, and the bill would clearly have been defeated, and the opposition parties asked for a division and a vote, actual vote on the bill, they were prevented from having the vote, and the bill was declared to be passed without a vote. So, and of course now the government is saying that they will curtail even this session, which is a very, very delayed session, because of COVID fears. Today, no public protest can take place. Wherever public protests are taking place, whether it is of farmers or students who are protesting against unemployment, they are being arrested for violation of the COVID lockdown rules or for violation of Section 144, which continues to be imposed in most parts of the country today. So, this is a time we are seeing that all our democratic institutions are being destroyed. The apart from the judiciary, the CAG has been brought totally under government control. We have never had a situation where on the government's instructions, the pricing details have been omitted from the CAG report on the Rafale jets audit of CAG. The audit of the offset contracts which were given to Anil Ambani's company, they were not done because of government pressure over CAG. We have a collapse of the election commission where election dates are being decided by the election commission on the instructions of the government, where model code of conduct is not being enforced against the Prime Minister or Mr. Amit Shah. And when one election commissioner said that this is not right and that these people are violating the model code of conduct and it should be enforced, the income tax and the enforcement directorate, etc., were set upon him, and they forced him to resign and take up a job with the Asian Development Bank. So we have now a totally partisan election commission. We have almost a collapsed parliament. We have a collapsed Supreme Court. We have a collapsed CAG, etc. We have a collapsed Human Rights Commission. We have a non-functional Lokpal, and we have complicit investigative agencies, whether it is the NIA or the CBI or the Enforcement Directorate or the Income Tax Department or the various police agencies in BJP-controlled states. And they are wantonly violating the fundamental rights of people. There is a concerted attack on minorities. there is an attack on dissenters and people who speak up against the government. There is an attack on activists. And the attack is firstly on the streets by way of lynch mobs. There is an attack on the social media by way of vulgar abuse and threats of violence, etc. And there is an attack by the investigative agencies by way of filing and prosecuting false totally and arresting activists and dissenters and persons from the minority community on totally false and fabricated cases, as has happened in Bhima Koregaon against some of our finest activists, or in the Delhi riots cases that we are seeing. So it is in these circumstances that we needed the Supreme Court and the High Courts to come to stop this, because that is one of their main roles assigned to them under the Constitution, to protect the fundamental rights of citizens, to protect democracy, to protect the Constitution. But we are seeing that the Supreme Court has just abdicated. They are not hearing many cases, whether it is the Ayodhya case, whether it is the CAA case, whether it is the Kashmir cases, whether it is the electoral bonds cases. Many critical cases are not being heard. And those cases which have been heard, critical cases which have been heard, such as the Ayodhya case, or the Judge Loya case, or the Rafael case, or the Birla Sahara case involving corruption in high places, those cases have been decided in accordance with what the government wanted, or the PM Cares Fund case, or the migrant workers cases, etc. They have hardly ever gone against what the government has wanted. And they have failed to protect the fundamental rights of citizens, whether it is people who are being beaten up or falsely arrested in bogus cases, or migrant workers who have lost their jobs and are without any money or income and are starving, etc. So there is undoubtedly a complete collapse, or almost near complete collapse, of the Supreme Court that we have seen over the last 6 years. Now the question is, how do we deal with the problems that we are seeing? What are the solutions? So as I said, on the first issue of having a judicial system which is accessible to the people, there was a Gram Nyayalaya Act which was made, which was supposed to be for setting up of simplified courts at the sub-tehsil level, at the block level across the country. And these courts would be closer to the people, would be more accessible without lawyers, because the CRPC, etc. would not apply to those courts. But unfortunately, that act which came in 2010, it's now 10 years old, it has not yet been implemented. For 10 years, they have not set up these Gram Nyayalayas. Then, on the question of delays, we need firstly more courts. The law commissions for many years, many law commissions, successive law commissions have said that we need to increase the number of judges and courts many-fold. And we need to have better quality of judges. One of the problems why cases get delayed is also because our judges are often very incompetent. Quite apart from being corrupt, they are often incompetent. They can't decide cases. They don't know how to deal with cases. Therefore, we need more courts and better judges. So, for that, the government has to allocate more funds for the judiciary, and the judiciary needs to display the political will to force the government, because access to justice is also a fundamental right. And it is the job of the judiciary to force the government to do whatever is required to enforce fundamental rights of people. So therefore, if the government is not doing it, the judiciary should force them to do it. But unfortunately, even that is not being done. Then we need, as I said, a better system for selecting judges so that more competent judges get selected. There is at present, see, selection happens at two levels. One is for the lower judiciary and then for the higher judiciary. For the lower judiciary, usually the selection is in the hands of the high courts of those states, state by state. And we have seen there are serious problems in the way in which the high courts are dealing with the recruitment. In some cases, they are with the state public service commissions. In some other cases, they are with the high courts. And there are serious problems in the way this is being done. There are written exams, but there are all kinds of problems in these written exams. Then there is selection for the high courts and the Supreme Court, which used to be in the hands of the government. But now it has been handed over to the, or rather it has been taken over by the Collegium of Senior Judges of the Supreme Court. They are now themselves deciding who to select. But the problem in this is, see, earlier also when the government had control, there was no transparency. And the government used to select people who were favorable to the government or who were weak, who would not be able to be independent of the government, who would not be able to stand up to the government. The taking over of this job of selection by the Supreme Court in their own hands and in the hands of the Collegium of Senior Judges of the Supreme Court has led to one minor benefit, which is that now judges who are being selected are perhaps slightly more independent. But the other problem of arbitrariness, nepotism in the selection, non-transparency, all those problems remain even in selection by the collegium. So we have a lot of nepotism in the selection. Recently, the brother of Justice Arun Mishra, who recently retired, one of the most notorious judges of the Supreme Court, his brother has been appointed in violation of the memorandum of procedure, which says that nobody below the age of 45 years can be appointed. But unfortunately, in violation of the memorandum of procedure, his brother was appointed. And despite the fact that his brother had in his social media posts can be seen to be totally communal, therefore he cannot honestly subscribe an oath to the Constitution, which every judge has to subscribe to. Means that every judge has to take an oath to protect and defend the Constitution. And a person who's totally communal obviously cannot say that I subscribe to the principle of secularism under the Constitution. But yet he was selected and appointed. So there is a lot of nepotism. There is no system. If you ask any, they have not laid down any criteria on the basis of which they select judges. I mean, it is astounding that there is no criteria on the basis of which judges are going to be selected. If you ask any Chief Justice, how do you select judges? What do you see? They will say that, well, we see competence and we see integrity. You can ask them, well, what about judicial temperament? Why don't you see judicial temperament? There are certain people who may be competent, who may also be honest, but they lack judicial temperament. What about their having faith in the basic structure or the basic principles of the Constitution? Why don't you see that? Is that not a relevant criteria? What about having some understanding of and sensitivity towards the common people of this country? Is that not a relevant criteria? And then how do you see the competence of these people? How do you see the integrity of these people? They will say, well, integrity we see on the basis of the IB report. I mean, IB report is not any basis on which you can judge the integrity of people. The IB reports have often been found to be totally bogus. And according to whatever the government wants, it's a government-controlled agency. How do you check the competence of people? they will say ki we read some of their judgments, but there are no judgments for people who are being appointed directly from the bar to the high courts. There are more than majority of the people who are appointed to the high courts are directly appointed from the bar. How do you judge their competence, etc.? So there is no system, there is no criteria, and therefore we need to have a proper full-time independent body which is independent of the government as well as of the judiciary, which does the job of selecting people on the basis of a laid out criteria, on the basis of a system which they define as to how they will judge people on this criteria, and with some amount of transparency. Today, when before judges are appointed, nobody knows who's going to be appointed. Suddenly one fine day notification comes that Arun Mishra's brother has been appointed. If people had come to know that he is going to be appointed, many people would have sent complaints that, look, this man is totally communal. He is below the age that your own memorandum of procedure prescribes. But today there is no transparency at all. There is no short list which is put out before the selection is made. Even the final selection is not put out before the notification is issued. So we need some transparency in that. And then there is the problem of lack of accountability of the higher judiciary. The only system that we have today for entertaining complaints or doing something to judges. You see, one good thing is that in order to make the judges independent of the government, the constitution does not give the government any disciplinary power over High Court or Supreme Court judges. The only way in which they can be touched or removed is through a process of impeachment, which is a very difficult and a political process. You need 100 MPs to sign the impeachment motion. By and large, MPs are very reluctant to sign any impeachment motion against, especially against a senior judge of any high court or the Supreme Court, because they fear a judicial backlash. The parties fear a judicial backlash. The individual MPs fear a judicial backlash, and therefore they are unwilling to sign unless two conditions are satisfied. First, that there should be unimpeachable documentary evidence existing about the corruption of the judge. And second, that issue should have become publicized and should have become a public scandal. Only then do people sign an impeachment motion. Now, that matter, or even if there is documentary evidence of misconduct or corruption of a judge, it doesn't get publicized because of the fear of the threat of contempt of court. Because the moment you write something or say something against a judge, you run the risk of being hauled up for contempt of court. You see, contempt of court is in two parts. One is civil contempt, which is disobedience of a court's order. There is no problem in making that punishable. Court's orders should be obeyed, and therefore you need some sanction against the disobedience of court's orders. The second part is criminal contempt, and criminal contempt is also divided into two parts. One is obstructing court proceedings or the administration of justice. So if somebody dances on the table of a judge and doesn't allow court proceedings to go on, or he threatens the judge, or he threatens a witness, or he threatens a lawyer, that if you decide this way, or if you give this evidence, or if you argue in favor of so and so, I will kill you, etc. That is clearly interference with the administration of justice, which should also be punishable. The problem is in the second variety of criminal contempt, which is scandalizing the court or lowering the authority of the court, for which I was charged also, just because I had made some comments about the collapse of the Supreme Court or its failure to protect our democracy during the last 6 years. This is the problematic part, because see, what is scandalizing is totally undefined. Any criticism of any judge or the judiciary in general would be considered to be scandalizing the court or lowering the authority of the court. And this is a jurisdiction in which judges act in their own cause. So it's a very, very dangerous jurisdiction. And that is why this scandalizing the court has been done away with. It originated in England because judges were supposed to be representatives of the king. And since you couldn't criticize the king, this was in the pre-democracy times. Therefore, you couldn't criticize judges, and it was regarded as contempt of court. But now, in any democratic republic, especially a democratic republic which is governed by a written constitution where people have the right, fundamental right of speech, where ultimately citizens are the rulers, and therefore they have a right to discuss every institution as to what is going wrong with any institution, what needs to be done to correct it, what kind of reforms are required. Therefore, you need to be able to freely and frankly discuss how much corruption there is in the judiciary, what is the problem of independence or lack of independence of the judiciary, etc. So, this part of the criminal contempt should be done away with. In fact, Arun Shourie, N. Ram and I had challenged it in the Supreme Court. But this Chief Justice listed it again before that Justice Arun Mishra, whose views were well known, and therefore we had to withdraw it, and now we have to file this petition in a high court. Hopefully, at some point, at some time, this particular part of contempt of court will be done away with, as has happened in most other countries. So we need a judicial complaints commission to deal with complaints against judges. Impeachment is not a practical system. We need a totally independent body which is independent of the government as well as of the judiciary, a high-powered judicial complaints commission to be set up. And they should be able to look at complaints against judges, thereafter have them investigated, if necessary, then try the judge, and thereafter order his removal or whatever disciplinary action or any action that needs to be taken against him. That's the kind of system that we need. In addition, you see, there is also, they have effectively choked off RTI so far as the judiciary is concerned. Initially, the Supreme Court was in the forefront of saying that right to information is a part of freedom of speech, and therefore it is a fundamental right in itself, and therefore candidates have to declare their assets, their criminal antecedents, etc., etc. But when it comes to applying the Right to Information Act to the judiciary, I find that they are backtracking. And that is not a good sign at all. In fact, even information about how many judgments are pending and for how long in the courts, cases which have been heard and judgment has been reserved but not delivered, even that kind of information is not being given. Information about how judges have been selected or what was the opinion of different members of the collegium, that information is not being given at all. So that also needs to be dealt with. Now I come to the second aspect about the independence of the judiciary, as a result of which they are unable to protect, or they have failed in their duty to protect fundamental rights, democracy, and the Constitution. So why has the independence of the Supreme Court been compromised? Firstly, we need to understand that, you see, independence of the judiciary means independence mainly from the executive and the legislature. It does not mean, some judges feel that independence means independence from accountability. Independence certainly does not mean independence from accountability. It is primarily independence from the government as well as from the legislature. So what has happened? Why has it collapsed in the last, particularly in the last 6 years? So the first thing that we need to notice is, which is something which happens often when there is a very strong government, it happened during the emergency also, that the judges become fearful. And therefore, if they are not very strong and robust, they become fearful of what the government might do to them, especially a government which can be seen to be using all the agencies, the IB, the CBI, the NIA, the police agencies, the enforcement directorate, the income tax department, all of them have been pressed into service by this government to harass its political opponents, to harass independent sections of the media, to harass activists, etc. And it seems that they are also being used to harass some judges. Now it's another matter because it's another matter that you can usually use these agencies only to harass people who have some chink in their armor. That means who have done something which is irregular, etc. And that thing can be then exploited by the government to blackmail them and to threaten to harass them, so that they then do whatever the government wants them to do. Then there is a problem of affiliations. You see, this government has not been allowing the appointment of independent judges. We have seen that very often, though they are bound by the recommendations of the collegium, but very often this government has just sat on the recommendations, not made the appointments for years altogether. And they say that unless you appoint our people, the people that we want, who are affiliated to us or to the RSS or to the BJP, or who may be totally compromised, who can be blackmailed by this government, until then we are not going to allow the appointments of independent judges who have been recommended by you. This is another problem. And therefore there are some judges, for example, this Justice Arun Mishra had clear affiliations to the BJP. He had invited all the BJP leaders to his residence for the wedding of his nephew, which he celebrated at his residence both in Delhi as well as in Gwalior. And he had invited Shivraj Singh Chauhan also, who went to his residence at the time when he was hearing the Birla Sahara case, where Shivraj Singh was alleged to have received 10 crores by way of bribes from the Sahara company. So, and yet he was hearing all these cases involving the BJP people, all these political cases were being heard and being decided all in favor of the BJP, each one. And he had clear affiliations to the BJP and he made no secret about it. He said in an open forum that the Prime Minister is a versatile genius, etc. So that is also a problem that we are seeing. Then there is the lure of post-retirement jobs. Unfortunately, this is a major problem which needs to be solved, that the government still has a lot of say in post-retirement jobs for judges, whether it is appointment as governors or appointment as Rajya Sabha members or appointments to various commissions or tribunals, whether it is permanent commissions or whether it is commissions of inquiry or whether it is these permanent tribunals, etc. So the lure of post-retirement jobs and retaining a Lutyens bungalow in Delhi is also a very serious problem which compromises the independence of judges, especially when they are nearing their retirement. But the other problem which Justice Shah spoke about and some others have also written about recently is the problem of this master of roster. You see, this notion that the Chief Justice alone can decide which case is to be heard by which bench, and therefore this is the reason why those 4 judges came out in that unprecedented press conference to point out that the then Chief Justice Deepak Mishra was misusing his powers as master of roster in order to assign politically sensitive cases to particular benches in order to get them decided in a particular way in favor of the government. And this has put democracy in danger. And this is what Justice Shah has also written about. He says that if the government is able to control the Chief Justice due to Deepak Mishra had that CBI case about that medical college regarding him. Justice Gogoi had this sexual harassment case about which the government had all the information and all the evidence, etc. So there was that case in which that Kaliko Pul, the Chief Minister of Arunachal, had accused both Deepak Mishra and Justice Kher, and there in one case his son, Kher's son, and Deepak Mishra's brother, for having demanded bribes from him, on which the then Lieutenant Governor of Arunachal had recommended a CBI investigation, but the government didn't allow that. So the government can use all these things to blackmail the Chief Justice, and if they have the Chief Justice under their control, then they have virtually the entire Supreme Court in their control, because every politically sensitive case can be sent to convenient benches. There will always be judges like Justice Arun Mishra who can be trusted. Arun Mishra was used as the man by 4 successive Chief Justices. Kher used him, Deepak Mishra used him, Gogoi used him, and thereafter even Justice Bobde has used him. So therefore, you can get every case that you want decided in the way in which you want if you send it to an appropriate bench. And therefore this system of the Chief Justice alone deciding, this has to be done away with. We need to have at least a collegium of 5 senior judges deciding firstly the roster by way of functional jurisdiction, that these kind of cases will be heard by these following 3 benches, etc. And then each case has to be randomly assigned to one of those 3 benches. Therefore, no one Chief Justice or no one person can decide for each individual case which court it has to be listed before. So, these are the various reasons why the Supreme Court has collapsed over the last, particularly over the last 6 years, as a result of which they have been unable to do their job of protecting our rights, democracy, and the Constitution. Now the question is, how do we achieve these reforms? I have broadly outlined the reforms that are required, but how do we effectuate these reforms? Who will do it? Because unfortunately the government doesn't want an independent judiciary. They don't even care about a functional judiciary. They don't care. For them, for the government, if the judiciary were to just go away, it would be just as well for them. They would be very happy if the judiciary were to go away, because one of the major roles of the judiciary is to check transgressions by the executive. So, government certainly doesn't want these reforms. And the judiciary also, the sitting judiciary also does not, or at least the senior members of the judiciary don't seem to be interested in any of these reforms, because they are comfortable in a system where they are unaccountable, where if the judicial system is collapsed, then this whole business of arbitration flourishes. Arbitration is an alternative way to get out of the judicial system and get cases decided through arbitrators. And all these retired, most of these retired judges are involved in the business of arbitration, in which they make enormous amounts of money. Many judges are earning crores a year through arbitration. They get about 2 lakhs per day of sitting. And sometimes the sittings may be only for half an hour. Sometimes they have 2 sittings in a day. So therefore, they are making crores by way of arbitration fees, and this arbitration business is flourishing because the normal judicial system has collapsed. Therefore, even the sitting judiciary is not really interested in judicial reforms. The real people who are interested in these reforms are the consumers of justice, the ordinary people who need a functional judicial system, who need an independent judiciary to protect their rights, etc., and for them to be able to get justice. They are the real stakeholders, and therefore they have to form a campaign or a movement for judicial reforms and thereby put pressure on the government as well as on the judiciary, and then only these reforms will happen. So this is what I wanted to say. Thank you very much.
Many thanks for underlining the challenges faced by the judicial system and the judicial reforms which are required. Many thanks. And before I look at the chat box, we have with us Kumar Ketkarji, and I would like to ask him give his comment and or raise some questions about the presentation. Kumar Ketkarji. Audio off. Your audio is off. You're not audible. You're not audible.
I'm audible now?
Yeah. Please go ahead.
Well, I wanted to ask Prashantji that for so many years, irrespective of which government is in power, there are a couple of lakh people under trial in courts, in the prisons, and no civil society movement, no media or no political party has taken their cause, and some of them are given beyond 10 years under trial, and not even charge sheets have been filed, no FIRs, no proper police cases. But there is no civil society movement or no social promotion of their cause and to sort out their problems. And to why our society has failed these people, who are mostly villagers, innocent, and many of them are Muslims and Dalits. So is it not our failure? That is question number one. And question number two, as far as the appointment of the judges or giving them posts like Gogoi got the Rajya Sabha, is it true that Jagmohan Lal Sinha, who unseated Mrs. Gandhi in 1975, was given a prime diplomatic post after Janata Party came to power? I don't know whether it's true, but it was said at that time that he was given a prime post. And having come to that topic, you recently mentioned that emergency under Indira Gandhi cannot be compared with this because this is a very vicious and very serious kind of dictatorial regime in comparison to emergency. So these are three questions. They are unrelated. The last are related. What are your observations?
So the reason why there is no civil society movement is because for any civil society movement, you need to organize the people. And the consumers of justice are not a very focused sort of functional group. They are anybody and everybody in our country. Therefore, organizing them is not a very easy thing. You see, trade unions are a more focused group. So therefore, they can organize more easily. There is no such union of consumers of justice or people who are facing trials, etc. Therefore, the job of organizing consumers of justice into a movement for judicial reforms is not an easy job. But it's a very important job, and it needs to be taken up by some people. And I hope that it will be taken up. You see, we run a campaign for judicial accountability and reforms, but it is not a kind of grassroots movement in that sense. It needs to become a grassroots movement of ordinary civil society people, and that needs a lot of political organization. It's not an easy thing. Everybody doesn't have that skill to do that.
No, but couple of lakh people under trials and human rights issue it is. How come that human rights issue does not figure in the debate or any kind of discourse while discussing human rights issues in parliament or in media or civil
No,
society
it
people?
does. It does figure occasionally, but yeah, I mean, see, these are people, by and large, people who are very poor, powerless, underprivileged, etc. People who are suffering in jails and so on. And therefore, because they are powerless, their issue doesn't come into focus in the eyes of the political parties or in the eyes of the media. That, to my mind, seems to be the reason. Now, you said about post-retirement jobs and Justice Jagmohan Lal Sinha. I don't think Justice Jagmohan Lal Sinha was given any diplomatic assignment, as far as I remember. But all that I can say is Justice Jagmohan Lal Sinha was offered. My father has written in his autobiography, Courting Destiny, that in fact, Justice Jagmohan Lal Sinha had told my father that at the time when this case, judgment in this case had been reserved, the then Chief Justice of the Allahabad High Court had come and offered him a job or promotion to the Supreme Court, and he said he was speaking on behalf of the government, if obviously in order to try and influence his judgment. But he did not agree to that. Justice Jagmohan Lal Sinha was a very, very upright. He was one of the most upright judges that one can have, one has had in this country. You asked about emergency or the judiciary during the emergency versus the judiciary now. Uh, See, during the emergency, though the Supreme Court kind of caved in, but several high courts had stood up. There were as many as 9 or 10 high courts which had said that habeas corpus is maintainable even during the emergency. At that time, on an average, we had, in my view, we had better quality judges and judges with more backbone in place in the high courts and the Supreme Court. It's another matter that there was certainly an atmosphere of fear, and the Supreme Court buckled down in that atmosphere of fear during the emergency at that time. But today what we have is not just fear, there is also fear because of this fascist government and its willingness to use agencies to harass people, including judges. But there is also, in addition to that, we have a situation where we have judges who are firstly incompetent, secondly very weak, who have no backbone, and so that is also why today the judiciary seems to have collapsed even more than what it did during the emergency. That's what I wanted to say.
Thank you.
I would like to ask Ravi to make a comment or make some questions, share some questions. Yeah, please.
Okay, thank you so much, Prashantji, for such a lucid lecture. The question I have, I ask every speaker of ours and all our friends and so on, is that when you have a threat to democracy, the values and institutions of democracy, from the processes of democracy itself, when these kind of forces who are destroying democracy, they do have significant mass support, significant public support to roll out their vicious program of destroying democracy. Then where do you see democracy can be shielded or protected? And from you, I would like you to shed some light on how resilient is the constitutional structure to protect itself from the vagaries of electoral politics?
Yeah. So, yes, it is true. I mean, this book, How Democracies Die, written by these two Harvard professors, Levitsky and Zimblad, it points out that today democracies across the world are dying through through governments which have come to office by elections, which are kind of majoritarian popular governments, etc. So the way that was designed by our constitution to protect democracy was to create an independent judiciary, to create an independent election commission, to create independent CAG, etc. And the idea was, unfortunately, it hasn't entirely succeeded in its design, especially where you see an overall degeneration of society. In fact, there was a book in the 70s by a man called, so it was called 4 Arguments for the Elimination of Television, and in which he had argued that television is going to have a very insidious impact on human psychology, on social behavior, and it will firstly shorten attention spans of people, it will degrade their capacity for critical thinking and make them more amenable to propaganda. To some extent, the advent of the social media has just accentuated that trend, which was started by television. And therefore, we have now a society which is whose attention spans have been depleted to 280 characters, or Instagram, which is 1 minute. They don't even want to watch a video. Of course, they don't even want to read anything which is more than 280 characters. They don't want to watch a video which is more than 1 minute. They don't have those kind of attention spans. And their ability for critical thinking has been degraded to such an extent that we have almost created what is called a post-truth society, where people have lost the ability to distinguish between truth and falsehood. So this is a very, very serious challenge, and this is perhaps one explanation. There may be other explanations also for the rise of the right wing across the world. People who are relying upon propaganda and therefore relying upon perception. I mean, our government just relies upon perception. The reality makes no difference. The Prime Minister can say that no, there is no intrusion of China into India. He can say that there is no job loss, and there will be a significant section of people who will believe that. So therefore, that's a very, very serious challenge, and I'm not sure of how that can be confronted. Of course, there is also an erosion of all our independent institutions. I mean, they have somehow subverted their independence by appointing weak or blackmailable people to all these institutions, by scaring them, by threatening the use of these agencies, etc. And thereby they have brought all these institutions to their knees, so that all these institutions just become instruments of the party in power, which was supposed to be independent. So there is lot of thought that is required on how. I don't have any easy answers to all this.
Bhargav wanted to raise some question. Bhargav from Karnool.
Go ahead.
Thank you very much, Prashant ji, for your very lucid and forthright presentation, and very important reforms that are required, suggested by you. I have a very minor thing. I was actually curious to know your choice of the words term, consumers of justice. You have used it, that it will be very effective if it is called consumer, or should we see in the concept or the definition of citizen itself the right to have a due process of law, whether for under trial or even for prisoners or convicts, which is embedded in the concept of citizen itself? Don't you see that, or do you have any other idea in mind when you're using that?
No, I don't have any other idea in mind. I am just using the term in a very literal sense. That people who want to use the court firstly to get justice, but who are unable to get justice through the system. They are the consumers of justice. But yes, you are right that this term does not include those citizens whose fundamental rights need to be protected. I am using that consumers of justice only for the first category of people who are unable to get justice in ordinary cases through this judicial system. So they are in many ways the main stakeholders, but there are also a lot of those who need the judiciary for protection of their fundamental rights or for protection of democracy or for protection of the constitution. In that sense, they may not be consumers of justice, but they are just citizens who need the courts to defend democracy, the constitution, and their rights. So yes, maybe a slightly different word can be used.
Sunish wants to know whether the Supreme Court of India is competent enough to challenge the foreign policy of the government, and he's mentioning the CAA. It's in fundamental rights of non-citizens. That's particularly the Article 14. He's mentioned Article 14, Article 21 of the Constitution, and how it has been violated. Whether the Supreme Court is competent enough to discuss that issue, because it involves other countries also.
Hello?
Yes, the Supreme Court can certainly examine the issue. It's not a question of foreign policy as such. It's a question of which citizens, or rather which persons would be given. You see, Article 14 and Article 21 both apply to non-citizens also. So the right to equality as well as the right to, of course, there may be certain things in which non-citizens and citizens cannot be equated. But when you are talking about giving citizenship to non-citizens, you can't discriminate on the basis of religion. You can't say, well, we will give it only to Hindus and not to Muslims, or we will give it to all others and not to Muslims. And you can't even say, we will give it to only these persons coming from these 4 countries and not to persons coming from other countries. If any refugee has come from Myanmar, say a Rohingya refugee, and if he has fled due to persecution, and you can't even say that we will give it to only those people who have fled religious persecution. All this is discriminatory. If he has fled ethnic persecution, as the Rohingyas have, it may not be religious in that sense. But how can you differently treat people, refugees who have come fleeing persecution, and say that we will only grant citizenship to persons belonging to these religions, coming from these countries, and only who have suffered religious persecution? That's not a matter of foreign policy. That's a matter of the right to equality for even non-citizens. Even non-citizens have the right to be treated equally under our constitution. That's the issue.
I have a question which is not exactly related to this debate, but few days back you discussing the Anna movement. You mentioned that RSS people were involved in it. If can you just make a comment on it, if it is comfortable?
Earlier, I was sort of vaguely aware that some of the people who were supporting the movement were from RSS or BJP. There is nothing wrong with that. People from any party or any walk of life can support an anti-corruption movement. There's nothing wrong with that. But I think later what I realized was that they had done it by way of an organizational decision by the BJP and the RSS that they must render all support from behind the scenes to this movement, and they were doing it for their partisan reasons in order to bring down the Congress government. That movement was certainly required. A Lokpal was required. The institution of Lokpal was required. Anybody could have supported it. What I feel unfortunate was that this BJP RSS took an organizational decision to support it for their partisan reasons. And had I known that earlier, that this is their kind of organizational decision and they are doing it in an organized manner, though from behind the scenes, and that they want to take political advantage out of it, probably I would have been much more wary of this.
And this is the last question which I would like to take. Aloy wants to know, given the fascist trend rising up in the country today, what are the chances for the democratic forces to confront the fascist power and rejuvenate democracy? What are the chances for democratic forces?
So I can see that right now public opinion has turned quite dramatically and quite decisively against this government. You can see that from the social media very, very clearly because on the social media, the BJP and the RSS are clearly on the back foot. And one of the reasons for that is the students' movement on the issue of unemployment. I feel that that's a very, and of course now the farmers' issue has also again resurfaced as a very big issue. I feel that in particular, if the students and the youth on this country can be mobilized, and the issue on which they can be very easily mobilized is the issue of unemployment. Then there can be, of course, right now they are using this COVID and lockdown, etc., to prevent any democratic activity. They are using it to shut down parliament. They are using it to shut down the courts. And they are also using it to shut down any kind of democratic activity or protests on the streets, etc. I think the time has come for people to launch a kind of civil disobedience movement around this lockdown and preventing protests and political activity. And the youth and the students in particular need to now come out and organize themselves. And I feel that if that happens, the political tide will turn. Of course, there will be still a lot of work to repair all the damage that has been done to democratic institutions. Even if we are able to get rid of this government, it will not be easy to repair the damage that has already been done.